Hello, all. Welcome to another session of this course titled Legal Essentials for Human Resource Management. This is week 1 and session 4 of this course. Now, today we would be discussing about definition of industry as well as definition of the word employer. Now, you should be very much aware and clear about the definitions of these two terms. Throughout this 30 minutes together, we will look at how these two terms have evolved over the years. To give you a small recap of what we've been discussing in the past session, we looked at how labor laws in general have evolved from those British era laws to various national commissions on labor to the modern day labor codes. Now, with that knowledge and with that clarity in mind, let's look at these definitions of terms, key terms like industry and employer. As you know, my name is Dr. Amis Sabalopanan and I am from Nalsa University of Law. Now, the first question you might ask is why is it so important to define these terms? Why is it so important to understand what is the real meaning of the word industry? Which means, why is it so important for us to understand which establishment is an industry and which are the establishment which doesn't fall under the definition of industry? Now, to answer that, or to make it clear why it's important for us to define industry, we discussed about an act called as Industrial Dispute Act, one of the cornerstone legislation of the country. Now, until and unless you define if it is an industry or not, a lot of provisions that are allocated for disputes within an industry will not be applied. The first thing a court would look is it an industry to begin with? If it is not an industry, a lot of provisions that we are discussing is not applicable. Same goes with employer. Until and unless you're not very clear who is the employer, we don't know who is liable to a lot of provisions. Until and unless we know who is a worker, we are not able to decide who will have those certain benefits provided by labor legislation of the country. So it's very important for us to know definitions of each and every key term in labor legislation. So let's look at industry in detail. Now, the cornerstone legislation of Indian labor laws are the Industrial Dispute Act of 1947, popularly called as IDA. Now, it came in around the closing months of colonial rule, and it has been retained over the years through certain amendments in between. And what is the purpose of this act, or what is the objective of this act? Is that first, to prevent, to investigate, and to settle various industrial dispute. Now, you must know that in a workplace, if the powers are not equal. Now, there is a workman, there is an employer, there is the objectives, the aims of both these groups would be not same all the time. And when it is not in the same page, and when they are not same, there could be some disputes. So, settling those disputes, investigate those disputes, and prevent those disputes even before it happens. What can we do? This act tries to find solution for all this. It also prescribes certain substantive rules on strikes, lockouts, layoff, retrenchment, and closure. What are these words? We'll discuss in detail going forward. But just understand that all the action outcomes of disputes, let it be strikes, lockouts, layoffs, closure, retrenchment, how to do it, what are the provisions for it, everything has been detailed in this particular act. Now, let's discuss the historical evolution of these terms. First, to begin with industry. Now, Section 2 of IDA Act is where all the definitions that we are going to discuss going forward is mentioned. There are other parts in the Act which we will discuss later when we would be handling industrial disputes as a specific topic. Here we would only be looking at the definitions. So let me start with a very popular case, which is D.N. Banerjee versus P.R. Mukherjee and others case. Now the situation was that there were two employees. One was a head clerk and other was a sanitary inspector of a municipality in Bengal. Now, owing to reasons of insubordination and other complaints, the chairperson, municipality chairperson, decided to terminate the services according to vote by the municipal commissioners. Now, the decision of termination was taken. Now, termination was taken forward by the municipal union, which claimed that it's a clear case of victimization. That led to a dispute between the workers' union and the municipality. Now, can this issue be addressed with provisions in Industrial Dispute Act? For that to happen, municipality has to fall under local municipality has to fall under the definition of industry. Municipality is actually a local self-government structure. Such structures, are they an industry? So this went to the court, and municipality urged that it's not an industry. Union said it's an industry, hence the provisions of Industrial Dispute Act is applicable here. Now, Section 2J of Industrial Dispute Act is what defines what is an industry. And the definition at that time used to be any business, trade, undertaking, manufacture, or calling of employees. So it's a pretty broad definitions that include all sort of business, trade, any sort of undertakings, manufacturing, or calling of employers, and they include any calling, service, employment, handicraft, or industrial occupation or avocation. So even if it is a secondary job of the workman. Now the term workman we will discuss going forward. So it is a very, very detailed definitions. Now, the court observed that it has to be considered even at the outset that industry can be carried on by or under the authority of central or state government or by on behalf of a local authority. So, court categorically said that even if it is under a state government or a central government or even a local authority, it still comes under the purview of industry. Now, the definition of employer at that time, which was mentioned in Section 2G, so that definition of employer was first when it is in relation to an industry carried out by or under the authority of any department of central government or state government. If it was under central government or state government, the authority prescribed in this behalf, or whether no authority is prescribed to the head of the department. So if it's a state central government, if the authority is central government or state government, it is either the head of the department, or if there is any particular authority prescribed, as in he is in charge of the occupation, he would be the employer. And if it is in relation to an industry carried out by or on behalf of a local authority, just as in the case that we are discussing, the chief executive officer of that authority would be the employer. So it categorically cleared the air regarding, will a local self-government, local authority, state government, central government authority, establishments can come under industry or not. So the relevance of this case, why we are discussing this, is that it clearly supported the idea that even non-profit or public welfare activities may fall under industry if they have a organized labor and service output. Doesn't matter. The definition of business tells you that it's a profit motivated activity, but law defines it a little different. So if it's an industry, doesn't matter even if it is non-profit or public welfare, still comes under the purview of industry. Another interesting case is the case of management of Safdarjung Hospital versus Kuldeep Singh Sethi. Now, what happened in this case is that the court acknowledged that certain services like electricity, water supply, public transport, which involve organized cooperation between employer and employees to provide a utility to the community, and these are material services akin to the industry. So even if they come under state, central government, the nature of occupation is such that they are material services, which is very much in line with how it happens in industry. So the court is acknowledging that. We agree to that. However, when it comes to hospital and educational institutions, the service that is given by a hospital or an educational institution, the service is dependent upon the professionally trained individuals. A hospital runs, unlike, let's say, the electricity department or a water supply department, through the professional skill set of the doctors. And an educational institute works due to the professional skills of the professors and teachers there. And hence, they are not just a cog in an organized industrial process, unlike what happens in an industry. So in the last case we have said ki it has to be industrious to become industry. There has to be an organized activity happening. The court said ki in case of hospitals and education institutions, in the traditional sense, that organizing doesn't happen and it is heavily dependent upon the professionals. Hence, they don't fall under the term of industry. So, professional services and public welfare were out of definition of industry after this. But still, there was confusions regarding what is industry, what is not industry. Now we know that if it's a professional service heavy, welfare heavy activities, then it's not an industry. We know that it doesn't matter if it is profit motivated or not, it still becomes industry. But objective definition or understanding of what is industry. And that's when this very famous case happened, which is called as Bangalore Water Supply and Sewage Board versus A. Rajappa, 1978 case. Now, to resolve all these contradictions of defining industry, all these confusions regarding defining industry, a larger bench of Supreme Court delivered this particular judgment. Now, the 7-judge bench undertook an interpretation of industry. They gave an exact objective definition of what is industry and what is not. Now, it gave what we call as a triple test. It's famously called as triple test to see what is an industry and not. So the 3 tests that is applied to see if something get classified as industry or not is, first, it has to be a systematic and organized activity. first basic thing, which has been acknowledged by the previous judicial interpretations also. So it has to be a systematic and organized activity. There need to be a organized cooperation between employer and employee. It's very important. So activity will only be happening if there is a organized cooperation, there is a unending cooperation between employer and employees. And it has been set up for the production and or distribution of goods and services to satisfy human wants or wishes. Why is it important? If it is merely for spiritual or religious nature, it's not industry. So what this triple test have done is to condense all the existing judicial interpretations regarding what is an industry, came up with a very expansive yet objective definition. So it said it has to be a systematic and organized activity. There should be a cooperation between employer and employees, and it should be for the production and or distribution of goods or services and to satisfy human wants or wishes, and it should not merely be a spiritual or religious in nature. Now, if any enterprise meets these criteria, prima facie it would be an industry under section 2J. So the court explicitly stated that the presence or absence of profit motivation or investment of capital is irrelevant to this determination. Doesn't matter if it is profit motivated or capital is invested or not. It doesn't matter. It's irrelevant. What matters is the nature of the activity. It has to be an organized activity, and there should be a specific employer-employee relationship in an organized manner. So this became a very what we call as a litmus test to identify if it is a industry or not. So of course, few categories were removed after this definition have come in, because it doesn't have to be merely spiritual or welfare. So purely spiritual and religious enterprises like making prasad on a small scale by monks, it has been excluded out of the definition. If it is single person or self-employment operation without hired labor, because there is no organized activity happening and there is no employer-employee relationship, so of course they go out of the picture. And domestic services, all the house help, maid, vagera, vagera, you employ them, they doesn't come under the purview of broader definition of industry. And of course, all the sovereign functions of the government, like law and order, legislative or judicial functions, all those key governmental functions, they also doesn't come under the category of industry. After that, if you look at how the definition have changed, some of the key milestone events that has happened is, first, the central government introduced an amendment to the Industrial Dispute Act in 1982, which was to again incorporate a lot of judicial interpretations and observations. But sadly, it was not implemented, and hence there were still issues happening regarding inclusion of certain groups or exclusion of certain groups, which I'll discuss in a moment after this. In 2005, in a case called State of UP versus Jaybir Singh, the Supreme Court voiced its frustration over still pending 1982 amendment. So there was a judicial, let's say, there was a pressure to the legislative to implement these amendments. So finally, in 2020, we started the session by telling that there are multiple industrial codes that are now applicable. One of the codes is Industrial Relations Code of 2020. So this particular code have imbibed all those amendments that we had thought in 1982. And now we have a much more crispier and clearer definition of what is industry. For example, before getting into that, let me give you a small brief of what is Industrial Relations Code. So, if you remember the National Commission of Labor recommendation, second National Commission of Labor, their recommendation, one of their recommendation was to bring together all the labor laws of the country into a single umbrella of labor codes, because either they are conflicting or too much laws is complex, and due to the complexity a lot of implementation of these laws is not happening. So this recommendation was clearly given by the second National Commission on Labor. So walking on those recommendations, the central government had merged some of the key labor legislations like Trade Union Act, Standing Orders Act, and Industrial Dispute Act. Each act we'll discuss while we discuss those functions in detail, which would be a little later in the course. So, what Industrial Relations Code have done is to merge Trade Unions Act, Industrial Employment Standing Orders Act, and the Industrial Dispute Act. They have also introduced certain fresh concepts like negotiating councils, reskilling funds, and even single tier adjudicatory system. We will discuss all that when we pick up a particular topic called as handling disputes. So, how have Industrial Relations Code 2020 defining this term industry? Now, industry means, according to IRC 2020, Industrial Relations Code 2020, industry means any systematic activity. So it's walking on the lines of the previous definition. Any systematic activity carried on by cooperation between an employer and worker. So again, the stress is given to this idea that there has to be a cooperation between employer and worker, and whether such a worker is employed by such an employer directly or by through any agency, including a contractor. So this is a change in IRC. We never spoke about contractual employees. Contractual employees in terms of the secondary employer would be there, which is a contractor, and the employees would be coming in through the contractor. Such workers were not introduced or covered in the previous definition, but the current definition of IRC includes those workers also. And for production, supply, or distribution of goods and services with a view to satisfy human wants or wishes. Now, this is exactly the previous definition. So, a change you will see here is how contract employees has been added into the broader definition. And of course, it carries on with the previous definition where it's not being wants or wishes, which are merely spiritual or religious in nature. And it doesn't matter if a capital has been invested for the purpose of carrying on such an activity, taking forward the judicial observations, and such activity is carried on with the motive to make any gain or profit. So the newer definition have incorporated all the judicial observations and changing needs of the time, and have given a broader, crispier definition of industry. It is also very clear what the definition does not include. It doesn't include institutions owned or managed by organization wholly or substantially engaged in any charitable, social, or philanthropic service. Very clear. So this is also extension of previous observations, where if it is a charitable, social, philanthropic service, it's not in the definition of industry. Any activity of appropriate government relatable to the sovereign functions of the appropriate government, including all the activities carried on by departments of the central government dealing with defense research, atomic energy, or space. So before there was this confusion whether defense research, space, and all comes under the purview of industry or not. Now this definition is very clear. They don't. They are also been put under activities that come under the sovereign functions of appropriate government. Similarly, domestic services is still not a part of industry definition or any other activity as may be notified by the central government. So that's the definition of industry as per Industrial Relations Code. And as I told, these codes are still not applicable, but sooner or later they might be. So it's, as a future looking student, it's important that you should understand this is the modern day definition of industry and something that is going to be used in a near future. With that, let me conclude today's session. If you remember, what we have discussed today is the definition of the term industry as well as the definition of term employer, and we have looked at how these definitions have emerged over the years, starting from the original definition given in Industrial Dispute Act to the modern day definition given in the Industrial Relationship Code. The next week next session rather, we will be looking at definition of worker, employee, employer, and industrial disputes. So stay tuned, keep watching the videos, and let's develop the much needed legal acumen while handling labor and employees at workplaces. Thank you so much for your patient listening.